What's up, everybody? It's Walter, your favorite historian and professor. Today's date is April 9th, 2026. This video is entitled Gaines versus Canada. This is a very old and nearly forgotten case in civil rights law that was the first major U.S. Supreme Court decision striking against the separate but equal doctrine in higher education. In this case, our petitioner, Lloyd Gaines, had applied for admission to the University of Missouri School of Law, but he was not admitted on account of his race. In many American states, African Americans were not allowed to attend law school, okay? In order to satisfy the Constitution's equal protection of the laws, as mandated by the 14th Amendment, the state of Missouri offered to pay his tuition to go anywhere else he wanted to go to law school, except, of course, the University of Missouri. Now, that might sound weird, odd, and strange, because it is, okay? They would rather spend all that money sending him elsewhere rather than just letting him attend right here in state. And believe it or not, this was a common practice at this time, ladies and gentlemen, for states that did not have integrated law schools. They would pay for the black student to go to school somewhere else in another state. Maryland, my own state, did the same thing until the state Supreme Court struck that practice down in 1935. A little-known lawyer who would later become a legend by the name of Thurgood Marshall was the one who led that charge to the integration of the University of Maryland Law School, in which case had a similar situation just like this. So Mr. Gaines filed suit against the registrar of the University of Missouri Law School, and this matter would ultimately proceed all the way up to the Supreme Court of the United States, which ruled in a 7-2 decision, okay, again, largely through the efforts of NAACP attorney Thurgood Marshall. The court would rule simply that the University of Missouri Law School's policy was unconstitutional, that the state had to either integrate its law school, thus allow black and other minority students to attend, or build a separate school for them in state. But they could no longer satisfy the Constitution's equal protection requirements by sending the black student or the minority student to another state to go to school. Because let's face it, there is nothing equal about that. The white student would get to go to school right here in state, probably down the street from their house, whereas the black student would have to pick up their entire life and move to another state to go to school. There ain't nothing equal about that. And as a result of this decision, we see the first major crack in separate but equal, all right? And that concludes our video. Thanks for listening. Professor Shelton, the blue-collar scholar, your professor and historian, out. Talk to you later.